Welcome back to another episode of Illuminating Information, the podcast where we shine a light on the cutting-edge technologies shaping the way we work, innovate, and navigate the evolving world of technology. Today's episode delves into part 2 of our conversation with Dr. Clara Hochleitner-Wanner, Master of Laws from the University of Pennsylvania Law School. In part 1 of our podcast, we covered the general introduction of the EU AI Act, when it came into play, and how it's impacting existing legislation like GDPR. Before listening further, we highly encourage you to listen to part 1 to get a better understanding of the overall conversation. Now, without further ado, let's jump back into this conversation. Now, earlier in our conversation, when we were talking about what the EU AI Act would sort of oversee and have implications on, you mentioned something called risk-based approach. Could you explain to us what is this so-called risk-based approach?
Yes, of course. So the AI Act differentiates between several types of AI systems, depending on the risk posed by this AI system to health, safety, and fundamental rights of human beings. On the one end of the scale, there are unacceptable risks leading to the prohibited AI systems that I have already talked about earlier. On the other end of the scale, there are AI systems which are only associated with a minimal risk. In between, there are so-called high-risk AI systems and other certain types of AI systems. So a very important category are the so-called high-risk AI systems. These are not prohibited, but they are very strictly regulated, in particular regarding the duties of providers of these systems. It is interesting that the definition of high-risk AI systems is outsourced from the AI Act itself in relevant parts, since there is a list of these systems only in Annex 1 and Annex 3 to the AI Act. Moreover, the Commission shall also publish guidelines with examples of use cases, but these guidelines have not been published yet. They will be published in February next year. And what is really remarkable, the Commission is even authorized to amend certain provisions in the AI Act regarding high-risk AI systems with the help of so-called delegated acts. Therefore, it's absolutely necessary in this regard to regularly review the different types of high-risk AI systems in order to be up to date here on the legislation. As of today, I can give you some examples of these high-risk AI systems, such as AI systems intended to be used as safety components in critical digital infrastructure or in road traffic or in the supply of water, gas, heating, etc. High-risk AI systems also would be systems intended to be used for the recruitment or selection of natural persons, in particular to place targeted job advertisements, to analyze and filter job applications, and to evaluate candidates. Moreover, high-risk AI systems also are systems that evaluate the creditworthiness of natural persons or establish a credit score, for example. Also, another high-risk AI systems would be systems that are used on behalf of competent public authorities, for example, to assess a risk such as the risk of irregular migration or a health risk posed by natural persons. And another example, which is very important for lawyers, would be a system which is used by a judicial authority or on their behalf to assist a judicial authority in researching and interpreting facts and the law and in applying the law to a concrete set of facts. So these kind of systems already exist and they are also already used in our area. If an AI system is classified as high risk, then there are several duties associated with this category. such as an organization has to establish a risk management system, then there are requirements of technical documentation and record keeping, there are transparency obligations, and, very important, the duty of human oversight. Also, accuracy, robustness, and cybersecurity are in a very high standard. Then the requirement of quality management systems and notification requirements, etc. So as you see, it is a very important part of the AI Act, and most of the provisions in the AI Act are linked to high-risk AI systems. Another type of AI system is the so-called general purpose AI. The short form is JPAI. Maybe you have heard of it. Examples for this are large language models, such as developed by OpenAI, Meta, or Mistral. In particular, these JPAIs come along with the duty of documentation and information. Moreover, there are also transparency obligations for providers and deployers of other certain AI systems, including in particular systems intended to interact directly with natural persons and systems that generate synthetic audio, image, video, or text content. These kinds of AI systems must fulfill transparency obligations so that natural persons concerned are informed that they are interacting with an AI system.
Thank you so much for breaking everything down for us. I know that there's a lot of information in there, but I think the distinguishing factors and delineating between the two is so important. So appreciate your insight there. Moving on to our next question. What are the most important consequences for companies coming along with the AI Act?
So, as I already mentioned earlier, the scope of application of the AI Act is very broad. So, it is recommendable to take a closer look at the AI Act rather sooner than later. On the one hand, some duties are relevant for a very broad spectrum of organizations, such as the obligation to take out AI training courses, it's called AI literacy. On the other hand, relevant duties depend on what kind of category of AI we are talking about. As I was just explaining earlier, it makes a difference whether we are talking about high-risk AI system or JPAI or just another AI system with a minimal risk. Companies could, for example, develop AI policies in order to define how these issues are addressed. In any case, awareness of the AI systems used in an organization should be increased.
Now, I know that we've covered a lot of information today, and it does seem like the AI Act is pretty comprehensive in what it covers and in its scope. It does beg the question, though, is the AI Act another example of overregulation, or rather, a progressive step in the EU?
So, the AI Act is a very relevant piece of legislation, and the EU has definitely set a new benchmark on the development and use of AI. In general, I am convinced that the AI Act contains many important points, such as defining prohibited AI systems or transparency obligations and AI literacy. However, I am also of the opinion that some duties, in particular regarding high-risk AI systems, are very complex and impose a very strict standard on companies and organizations. So I also understand to some point that companies complain.
Thank you so much for outlining everything for us today, Clara. Before we go ahead and conclude the podcast episode, I did just want to ask, do you have any closing comments for our listeners today?
So, as I already mentioned before, I think that it's very important that companies should have a look at the AI Act and that the awareness of what kind of AI systems are used in a company should be increased. And it's not only looking at the AI Act, but also at the other regulations. And companies should know whether there are any risks associated with the kind of AI systems they use. And it's not a good way to close one's eyes because of some problems. We just should focus on how we can deal with the AI Act and how we can see it in a positive way.
Well, thank you so much for taking some time. A huge thank you once again, Clara, for joining us today to illuminate this EU AI Act. As AI continues to evolve, staying on top of regulatory developments like this will be key for businesses, industry leaders, and innovators alike. Have a question or topic you'd like us to cover in a future episode? Know someone who might be a good guest on our show? Reach out to us on our website and let us know. Stay curious, stay adaptive, and as always, keep illuminating information.